Right, we'll get underway. Hello, everyone, and welcome. My name is Mitchell Zaddo. I'm the Managing Principal at Sharrock Pittman Legal, and thank you very much for joining us for our webinar today, part 3 in our series on property law and issues in property law. So before we get started, we would like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which we meet here at our office, and we pay our respects to their elders, past, present and emerging, and we extend this respect to all First Nations communities throughout Victoria and wherever you may be logging in from. If you haven't joined us for one of our webinars before, or if you have, again, a very big welcome. We offer these regularly and hope they're a helpful resource to share with you some must-know information and guidance on different legal topics that are of interest and that we are seeing in our practice here at Sharrock Pittman Legal. You can catch up on the recordings and slides for our previous webinars by heading to our website and clicking the link for the resources page. This webinar also will be recorded and put on the website shortly. So if there's anything you miss, feel free to catch up later on. Today, we're continuing to look at the important area of property law and more specifically, the opportunities, benefits and pitfalls of embarking on land development. The team will be discussing some of the common queries we get in this area, including what kind of ownership structures should be considered and what stamp duty concessions may be available. This is also an area where there's lots of information around and lots of options, of course, and there can be a danger in taking a one-size-fits-all approach. So we hope today to give you some good handles on the things you need to know, and then do feel free to get in touch if you have any specific queries later on. So I'll shortly hand over to Andre Ong, who'll start taking us through today's content. Andre's my fellow principal lawyer here at Sharrock Pittman Legal, and he's also an accredited specialist in property law. He has many years of experience in this area and really is an expert in the field. So I know he's looking forward to sharing his knowledge with you today, as are our senior property lawyers, Sheba Rao and Sabina Mera, who join us as well. Before I hand over to Andre, just a couple of housekeeping things to run through. We're obviously here in webinar mode, so your camera, and we are recording the session, as I mentioned before. If you have any questions throughout the session, please feel free to type away in the Q&A box at the bottom of your screen. We'll try to get through questions as we go, and we'll also have some time for questions at the end. But we are conscious of time, and your time. So if we don't get to all of the questions in the allotted time, don't worry, we will get back to you afterwards. And we'll also share our contact details in the slides at the end too, so you can feel free to contact us anytime. Before we begin, we do have to put up some fine print. We're lawyers, of course, so needless to say, we can only give you some general guidance in this session. Everyone's situation is different. It's really important to keep that in mind when it comes to your property ownership structuring. So please keep that in mind as we do go through today's content, and before doing anything, get some specific legal and tax advice. And also keep in mind that our discussion today, particularly in relation to things like stamp duty, is based on the law here in Victoria. So if you're looking at property development elsewhere in Australia, certainly get some specific advice in that jurisdiction. So without further ado, I'll hand over to Andre. Thank you, Andre.
Thank you very much, Mitch. As Mitch said, so we'll run through a few different options today with respect to property development. Now, I might just go to that previous slide, actually. There we go. The way I thought we'd go through this, just for ease of everyone's understanding, is to go through a bit of a simple case study. So we've got 3 individuals here, Bob, May, and Raj. They're either intending to acquire or already own a property at 3 Growth Lane in Glen Waverley, with a view into developing it into 3 townhouses. Now, we've got here 3 different people who have slightly different objectives with respect to engaging in property development. Bob's coming in wanting to just develop, build, sell it immediately, basically take the cash and run. We've then got May, who wants to develop now, build it, but retain it, take some rent for a while, maybe settle it at a later date. And then we've got Raj, whose intention here is to get this thing built, but actually live in it as his home in the long term. So looking at this kind of position, and as obviously is common with different projects, you've got parties coming in, wanting to come together to bring their resources together to develop, and having slightly different intent in terms of what they're trying to get out of the deal. So looking at this, what have we got as our options in terms of structuring this between them so they get the outcomes that they're after. So I'll run forward into the next slide. So the way we'll break down today is Sabina Mera will go through running through this project as a joint venture or partnership. What about partition arrangements, relevant stamp duty considerations and exemptions in that situation as one alternative structure? Shubha Rao will then go through what about using a unit trust? That is a pretty common structure in terms of property development, especially in terms of multi-lot unit development. So again, what's involved in doing that? And then I will go through at the end in terms of, well, what if the land actually was owned by May and Raj, and we have Bob as the builder coming through and effectively helping May and Raj achieve their specific goals, which are a little bit more in line with building and holding for a time or building and living, whereas Bob just wants to make a profit out of the project. And he can facilitate that by getting a piece of the land, in effect, getting a piece of land either in cash form or lot form from the development. So we'll work through all of those different options and the tax implications of each. So Sabina, I will hand over to you to run through the joint venture and partnerships. So, Sabina, you're still on mute.
Thank you, Andre. Good morning, everyone, and welcome to the webinar today. So choosing the right legal structure is really vital when thinking about land development. So while there could be several legal structures to consider, we are looking today at two popular legal structures, or I'll be discussing two popular legal structures here used in land development, which are partnerships and joint ventures. So while both the structures have similarities, there are key differences that make each structure unique. So let's begin with understanding what a partnership is. Next slide, Mitch. So a partnership is a relationship between two people. Well, it exists between people carrying on a business with a common view of making a profit. So usually it's two parties and up to a maximum of 20 other individuals or entities that are carrying on a business in common with the view of a profit in the end. In this scenario, each partner is jointly liable for all their debts and obligations. So unlike a company, a partnership is not really a separate legal entity. The partners are all jointly and legally responsible for the debts of other partners in their partnership. So example, if Bob, May and Raj are in a partnership, they will all be responsible together for all their business debts. So I would also like to discuss some of the key advantages of using a partnership structure. Mitch, thank you. So one of the key advantages of having a partnership structure is that it's relatively inexpensive to set up and has low ongoing costs. All the partners, they work together with a common business goal. The partnership structure also allows sharing of resources, labor, skills, equipment. There's also opportunity for income splitting. So the partnership itself doesn't pay income tax on the profit it earns. Income tax is assessed based on each individual partner's net income from the partnership. So, and also you can easily change the business structure down the track when you're using a partnership arrangement. So also I'd like to point out that the partnership's actually governed by the Partnership Act in Victoria. So there is actually legislation behind it. So some of the key disadvantages, however, is that with partnerships, it can be very inflexible, and it can put really onerous fiduciary duties between each of the partners during the duration of the partnership. So there is a duty of ongoing good faith between the partners, but it can get to be very stringent those duties can be quite onerous. So the partnership basically, the the problems with the disadvantages, one of the key disadvantages is that, the debts are equally owned by all the partners and they're responsible. The risks and liabilities lie with all the partners. So if one partner has the capacity, doesn't have the capacity to pay the debt, then it becomes the other partner's responsibility to fulfill that. And one party or a partner has the capacity to bind the others in the partnership as well. So partners are not entitled also to individual profits and for their efforts in running their business. It's all part of the actual partnership structure that takes on the profits. Sorry, can I have the next slide, Mitch? So having seen the partnership structure and looked at its merits and the pros and cons of it, we look at the next structure, which is a joint venture. This is quite a popular legal structure, and it is usually an arrangement between two or more parties where each individual, it could be either an individual or an entity, where each party retains its own separate identity, but they work together through the joint venture, but for a limited period of time. So there is a common goal, however, but each purposes might be different, and it's generally used for short-term or long-term projects. In property development, it's generally looked, the people generally go into a limited time frame joint venture. So the joint venture structure can be either an unincorporated joint venture where the individual parties actually determine their rights and obligations, or an incorporated one where a company needs to be established to run the business activity or the venture. The joint venture is established through a joint venture agreement between the parties, and it usually takes into form of a shareholders agreement if there is a company involved, if it's an incorporated joint venture arrangement. Again, it all depends on how the wording of the joint venture agreement is, the drafting of the joint venture agreement. It needs to be very specific and clear to set out the obligations and rights of each parties. Can I have the next slide? I'm sorry, Mitch. So there needs to be also, so some of these matters listed in this slide are related to what other matters can be considered in a joint venture. Could be the day-to-day management of the finances, responsibilities, processes. They can all be dealt with in the actual joint venture agreement, the methods of funding, contribution. Usually each party brings in their own, the liability of each individual or entity is actually limited to the portion or proportion of interest that they're actually putting in the actual venture. It's important to actually have proper dispute resolution mechanisms in the joint venture, because the purposes of each of the individuals vary, and that can also result in conflict between the parties. Therefore, it's vital to actually have proper dispute resolution mechanisms in the joint venture agreement. The tax implications on the joint venture basically depends on what sort of joint venture structure you're actually moving in with. If it's an incorporated one or an unincorporated one, so you need to actually seek your own legal advice, taxation advice, and see your own financial advisor in relation to that. Next slide. So some of the key advantages of using a joint venture structure is it is attractive special purpose vehicle. It's used for short-term or one-off projects. It offers a way for the parties to combine their skills and resources, and it's without changing the actual ownership of their existing assets. It allows businesses to access new markets, to gain new enterprise, and the tax obligations, of course, vary depending on whether it's incorporated or unincorporated. And one party of the joint venture does not have the capacity to bind the other joint venture, other party to the joint venture, as we saw in partnerships. Partnerships are pretty binding on all the partners. Some of the disadvantages are that they are very similar to a partnership. So the wording of the joint agreement has to be drafted. It has to be very clear to separate it from a partnership. Because the parties have got their own individual purposes or goals behind it, as we've seen in with Bob, who wants to sell the property after subdivision's completed, and May wants to rent the property, and Raj wants to live in it. As all the parties have got their own individual purposes, it's hard to somehow get the same level of commitment to the joint venture when parties are heading into it. So, and which again can rise to conflicts, and because of those commitment issues. So it's important to actually have that recorded in the agreement. So in this case study, we've got Bob, May, and Raj as co-owners, and they are, for the purposes of the case study, they are actually using an unincorporated joint venture as a structure. So in order to achieve what they have to achieve, the steps that need to be undertaken are they will need to first seek individual taxation advice from the accountant or financial advisor. Then they enter into a partition agreement to record their intent and purpose. The next step would be to proceed with the subdivision of the land into 3 individual lots, and then apply for stamp duty concession exemption assessment under that category, and then complete the partition transfer on PEXA to finalize the ownership of the subdivided lots into their own individual names. So, sorry, next slide. So next comes the question, in order to do that, a partition agreement needs to be entered into. So what is a partition agreement? So it's really an agreement between the co-owners of the land, and in this case, it's Bob, May, and Raj. They'll actually need to enter into an agreement which will record how the property is going to be split between each of these owners after the subdivision process has been completed. So the purpose is, of course, each one owns their own individual lot 100%, and then they can do with whatever goal they want to achieve at the end of it. The timing of the partition agreement is quite vital because it needs to be entered into before the subdivision process or land development actually takes place, to record clearly the intent and the purpose of the parties. This is important because when the documents go across to the State Revenue Office for stamp duty assessment, they will look at the partition deed as to when it was entered, when the subdivision process was actually completed. The partition agreement, so as I said, this is an evidentiary requirement, and that's needed for stamp duty assessment. Next slide, Mitch. So after the partition agreement has been entered into between the parties, that's when we can then commence the subdivision process. I'd like to point out here that the subdivision into the 3 lots does not actually mean at this stage that after subdivision, each party will own their own individual lots. There is another step that needs to be undertaken. So after the subdivision, you will have 3 separate titles issued for that same block of land. However, they will still be issued in the names of Bob, May, and Raj. There will be another process through PEXA, where they will need to actually have a complete partition transfer to have their own individual lots. So after the subdivision is completed through SPEAR and the registration is completed, that's when we can commence the next stage to complete the transfer. Next slide, Mitch. So we then complete the stamp duty component of it. This is before we can proceed with the partition transfer. So there is no stamp duty payable at the partition transfer if and only if the original ownership is retained and each of the 3 lots are valued the same, which is before and after the subdivision. So if Bob, May, and Raj, they all own 1/3 shares each in the property, and that ownership does not actually change after the subdivision is completed, and that is the intent recorded in the agreement, then there will be no stamp duty payable if the value of those lots remain the same as well after subdivision. However, if one of the 3 lots is valued at more than the other after subdivision, then stamp duty will be assessed on the difference between the 2 values. Well, Section 27 of the Duties Act actually deals with these requirements by the SRO, and there are several evidentiary requirements that need to be met in order to satisfy the duty requirements and to see whether and to be assessed for stamp duty exemption. So one of the applications usually consist of the partition agreement, statutory declarations by the parties, valuations, and the plan of subdivision. And then the next step would be to complete the partition transfer on PEXA once the assessment for stamp duty is made. Sorry, next slide, Mitch. Yeah, so once the partition transfer is completed, that's when the actual outcome for Raj, Bob, and May would have achieved their purpose of obtaining the actual lots. So while the partition arrangement is simple in concept, it can have tax consequences, and we'd like you to be wary of that and seek your own tax and financial advice before considering land development. But what about other alternatives? And I'd like to now invite my colleague Shubha to discuss the next part regarding unit trusts as an alternative to legal structure for land development. Thank you.
Thank you, Sabina. Good morning, everyone. So I'm discussing the topic where if Bob, May, and Raj wish to purchase and develop the land in a corporate type of group structure, the most common type of trust that is established by persons entering into a business venture together is a unit trust. In a unit trust scenario, the trust fund is divided into a number of defined shares called units, and the beneficiaries under that trust are called unit holders, and they subscribe for units in the same way that shareholders in a company subscribe for shares. It is crucial prior to the purchase of any land that advice be obtained in terms of how to structure the corporate entity that's being looked at here, because there are trips and traps with respect to additional stamp duty that may apply if the structure is not correct at the initial stage. If a unit trust purchases enters into a contract to purchase property, and then there are changes to the composition of the unit trust, then additional stamp duty may apply for the increased portions of units that are being held by any of the unit holders if certain thresholds are met. And also, if a nomination is undertaken after land development has been done on the property, then there is a risk of double stamp duty applying as well. So to avoid any of these scenarios arising, we always recommend that clients contact their legal advisors to obtain structuring advice in their matter. Next. So in our scenario here, as Bob and May want to undertake this project for profit-making intentions, they will be holding their units through their family trust to take advantage of income streaming in the future as well. Since Raj wishes to live in one of the completed townhouses as his main residence, he holds the units in his own name. So over here, the trustee will be the property owner, and the units will have, there'll be 30 units in total under the trust, and Bob, May, and Raj will then have 10 units each. So once the purchase, development, and subdivision of the land completes, each of the 3 lots will be held in the name of the trust, with the BMR Pty Ltd as the trustee. Raj will then seek to have lot 3 transferred into his name solely, and Bob and May will continue to operate through the trust with respect to lots 1 and 2, and no in-specie distribution to the family trust will occur as yet. Next slide, Mitch. Yeah. So with respect to transfers of a property to a unit holder, the State Revenue Office does have an evidentiary manual that will need to be, adhered to in terms of providing the relevant documents and evidence to the State Revenue Office to seek the exemption to be applied to that property transfer. The requirements to be provided to the SRO do vary depending on the type of unit holder. In our case, as Raj is seeking the in-specie distribution, we will be discussing the SRO's requirement for distributions to a natural person unit holder. So this falls within Section 36B(1) and 36B(2) of the Duties Act. I've listed the main elements that are required to be satisfied to claim stamp duty exemption. These elements, there is overlap with other transfers for other unit holders as well. So this information, you'll be able to replicate for other unit holders too. So the main elements that need to be satisfied, the first one is that stamp duty needs to have already been paid at the time of purchase. So over here, this should be reasonably easy to identify. Now that all transactions are done on PEXA and everything like that, stamp duty needs to be paid at the time of purchase. There's also confirmation that the unit holder was a unit holder of the trust at the time that the trust acquired the property. So in our scenario here, Raj has been a unit holder since the beginning, since the trust was established. So this criteria would be easily satisfied as well. If there have been changes in a trust from when the trust was first established to when the trust actually purchased the property, then you'd actually have to go back through all the register of the unit holders to establish that that particular unit holder seeking the transfer was actually a unit holder in the trust at that relevant time. The most important factor that needs to be addressed is the fact that there should be no consideration paid by a unit holder for the transfer of the property to them. Now, to a common person, no consideration would mean that that there's just no exchange of money between the parties. So Raj does not pay the trust any money for the property being transferred to him. But the actual concept goes beyond that. And what the State Revenue Office actually looks at is that whether there, as part of the evidence, you have to provide 3 years worth of financial statements for the trust. And if there are any loans, beneficiary loans listed within those financial documents there, then it has to be addressed as to whether any of those loans are going to be forgiven or they're going to be paid out. And if that's if any of those scenarios apply, then the State Revenue Office takes the view that that is consideration and stamp duty will be assessed on the transfer. So the recommendation is that any beneficiary loans need to actually be looked at to determine if they're actually truly loans to the trust or if they are actually equity that that particular unit holder has put into place. Or if not, what other options are available to deal with those loans that are there. In a similar way, if there's any mortgage on the property that's being transferred, for it to be considered that there is no consideration on the transfer, then Raj would then need to either assume full liability under the current mortgage on the property, or he would then need to refinance that mortgage. And the amount that he needs to refinance it for can't be less than whatever the current mortgage is on the property. So details of the mortgage, including what the initial mortgage, what the purpose of that was, whether it was for the purchase, whether it was for the improvements on the property, or if there was a refinance involved. all of that needs to be provided to the State Revenue Office as well, to back up this position that the exemption is eligible, that they are eligible for the exemption. One of the other factors is the dutiable value of the property being transferred. So the dutiable value of the property that's being transferred to Raj cannot exceed the value that he's entitled to the net assets there. So if lot 3 is 1/3 of the net value of the assets, then yes, that criteria is satisfied, and the exemption can apply. If the value of lot 3 increases, is higher than a 1/3 proportion, then the stamp duty exemption will actually not apply for the full amount that's there. The next one is that if the value...
I'll just interrupt for a moment. Just had a couple of questions.
Oh, yeah.
Through. We'll just look at now. The first one I might throw to you, Andre. Do we need a petition agreement under a unit trust setup?
Yes, I'll just jump in there. So no, the partition agreement structure is really related to the partnership and joint venture arrangements that Sabina has spoken about. With the unit trust, in terms of the legal documentation side of things, you will need a trust deed at minimum to establish the trust, but we would also recommend a unit holders agreement so that you're capturing what each unit holder is actually bringing into the project, what the expectations are between the parties, and obviously exit strategies if we're talking about 3 people here with different particular intents. The follow-on question from Indy on the chat was also whether the considerations on the refinancing with the other 2 partners in this sort of 3-party unit trust, when Raj is refinancing the loan to get the home that he's going to live in, it is proportional across the trust. So it is one where, again, we'll have to closely look through the applicable figures there. But as Shubha has just said, it's a matter of proportion of interest. So what the SRO is looking at specifically is to make sure that Raj, in receiving the property, is not actually getting any greater interest than what his original unit interest was in the property. So on a simple example, property is owned by the unit trust, Raj owns 1/3 of it. As long as he's getting a net 1/3 out, factoring in that he's refinancing effectively 1/3 of the mortgage, then that's what the SRO is going to look at for that duty exemption. Bearing in mind that the other 2 are obviously working through sales and will get or sales or maybe holding to rent and will work through their own financing arrangements that way. So I'll hand back to you, Shubha.
Yep. All right, no worries. So I think just the slide before. So I was just at point 2E. So the value of unit holding in the trust. So once the transfer takes place to Raj, then as long as his unit holding is decreased to account for the fact that he's got this property now, then that would be eligible. So his unit holding, I guess, will then go down to a nil basis to show that his full benefit has been taken by the transfer of the trust that's there. So now with respect to an overall perspective that the SRO takes, they do look at the whole transaction to see if it is a genuine one that's being undertaken by the parties. And so it can't be one that's part of the State Revenue Office deems to be as part of a sale or any other transaction that is being undertaken to try and just obtain the benefit of the exemptions that are available under the trust. So it is important to get all the evidence correct at the first instance, because if there is any, if the SRO doesn't agree and states that stamp duty needs to apply, then the taxpayer is the one that will need to be going through those objection processes or even litigation in terms of trying to reverse the SRO's assessment that has been done by them. So with Raj's property now being held in his own name, then May and Bob will just continue with their process in respect to their profit-making intentions, and they will need to seek accounting advice as to whether they, with their profits and everything, whether they get taxed at the unit trust level, or if it's better for them to have that taxed at their individual financial trust, family trust level that's there. So now in the scenario that if Raj was actually not going to have the intention to actually live in the property, then this transaction could have been completed through a company. But it's just a company doesn't have the ability to be able to distribute properties to any of the shareholders or anything. So if any unit holder has that sort of intention, then a trust would need to be the way that that's done. If there is only profit-making intention, no one wants to live in any of the completed properties, then a company can be undertaken as the vehicle for the development. So I'll pass it now to Andre for the development agreement.
Thank you very much, Shubha. And just to flow on from that, I think Shubha's just reiterating the fact that everyone's circumstances are slightly different, and it's important to get both legal, tax, and financial advice in terms of the best way to work through things and the outcomes that everyone wants, just to cover off those different aspects, not least of which on the financial in terms of actually funding the development. So I'm going to come at this with a slight twist in the picture in terms of Bob as builder, basically coming into the situation, wanting to facilitate the development for May and Raj. So we still have the three intents in mind, except now Bob's really, in terms of trying to get paid out of this project, is after the money. He's not necessarily after it as a specific lot. Albeit if we move this example from 3 Growth Lane in Glen Waverley to say 3 Growth Lane in Gisborne or Druin, then we might be talking acreage, and Bob may well want to land bank that back lot as opposed to having it as one lot. Perhaps that's larger acreage, etc. And there are different considerations when you're working through that. The idea of this sort of structure with Bob coming in from the outside is that Bob, as the builder or developer or project manager, however you may term him, is really coming into this project wanting his profit out of it, but not wanting to be hit by stamp duty as if he were a part owner of the property. He's putting his skills in, he's putting in some funds perhaps to get the project up, running, developed. May and Raj are going to be putting in the land, most likely putting in some additional funds as well, and they're going to get their houses out of it. But Bob's really just looking at this as a financial transaction for him. So this sort of diagram is showing you the intended start position with Bob coming in from the outside, and then the intended end position. So I'll move across then to the next slide, Mitch. So with Bob coming into the picture like that, and assuming some level of pre-existing relationship between May and Raj trust-wise, really there should be a development agreement put in place between Bob, May and Raj so that there's clarity as to who's going to get what's going to be the end outcome to this. And I thought I'd just run through some of the key conditions that you would consider in putting together a development agreement. I mean, obviously, initially, what's everyone trying to get out of this? And at this point is probably the part where Raj and May might have a discussion in terms of what they're looking to get out of it, short-term, long-term. From Bob's perspective, is he just after cash? Is it just the profit question? Or is he actually, say this was acreage out in some of the outer areas or original area, perhaps he's after the land as a long-term land bank proposition. Obviously, there's stamp duty as applicable if he were actually to get on title, but that is all relevant to the way this is going to be structured and timeframes for this, because duty is only going to apply if Bob's actually going to end up on the title. And then we've got value considerations there as well. And then some practical implications. What's Bob actually delivering? Is this a turnkey project? Are Raj and May going to get literally houses they can just walk into, or something less than that? We have done arrangements in the past where the external developer is sort of getting it to a point, and then the existing landowners might do the finishing or whatever it may be, depending on what they've agreed. Obviously, Bob should be setting out the extent of the services that he's providing. Project feasibilities, development, facilitation, tendering, project management, design, build. Is he helping with the financing? Is money coming through from Bob? That actually becomes relevant later on when we talk about the stamp duty implications of this, because even though the structure is being considered as a way for Bob to be inputting into this land development without necessarily incurring a stamp duty implication, that's not always going to be the case. And the SRO, the government, had changed rules a few years back now to put in place economic entitlement duty, which I'll address in a second. The next key term is really to go through what are going to be the decision-making processes with this development, who's got control. If you're coming at it as Bob from the outside delivering a product to Raj and May, you don't particularly want to have Raj and May, I guess, interfere with the ability to get to that end goal. At the same time, if you're Raj and May, and especially if you're Raj and you're building this as a home to live in, you might want significant input and control, at least to the extent of your home, so that you have the product that you actually want. And obviously, this is just a natural tension between builder delivering a product and the landowner, homeowner wanting to have their dream home. But you want to be able to set those positions at the outside. Who's got the control processes? What's the deal breakers that are in place? And if those things happen, how do you resolve that? Risk allocation obviously is relevant. You start, construction, or you start digging into the land, you never know what you'll find. Who's going to bear that risk? Is it a landowner issue? Is it a builder issue? Again, especially if we're talking at this time with post-COVID, the material shortages that are there, the cost increases that are definitely making their way through the construction industry. What's going to happen in that situation? Is that in effect something that Bob is bringing into the picture on the risk side as part of the value that he's delivering? So that's something, again, to be discussed and worked through. Resources and contributions into the project, especially on the financing side, is crucial, especially if there are anticipated increases in costs over time, something to definitely work through and have certain between the parties, because you don't want to get partway through a project and suddenly run out of the lifeblood, being cash of the project, and then not being able to deliver it. I mean, there's nothing more worthless than a half-complete site in some respects, because you're not getting the value of the work that you've put into that half-complete site. So it's important to have that planned out and to make sure that everyone's on the same page with what's got to come into this project to get it to completion. Then there's obviously some practical issues that should be considered. What's actually going on the site at the moment? Do May and Raj have to move out of a home? That kind of thing. Now, here's where we start to have some stamp duty implications come into the picture. When we're talking about remuneration and what's Bob going to get out of this and how is he going to get the profit out of this, then economic entitlement duty comes into play, because obviously Bob can get paid in a whole bunch of different ways. Is it just a fixed fee that he's agreed to? Is it going to be a profit share on the sale of that third lot? Is it going to be some combination of both? Is he getting some fee for service for the lots that May and Raj are keeping in effect, and then some profit out of the third one? These are the things that are going to be considered to make sure that the project adds up for Bob. But that calculation and how you set it up in the development agreement will actually impact whether stamp duty might apply to this circumstance or not. And I'll run through that when we get to the next slide. Plus a few points there. What about security for Bob's contribution into the property? Because obviously Bob's not on title. He's putting in a lot of work, some money as well into the project. Is that going to be charged against the land? How's that going to impact, if we're getting financing coming in and lending coming through for construction? Obviously that may not work the best in terms of the security. So there's got to be some consideration of that from Bob's end in terms of the protection for the work that he's putting in. And then at the end, we just need to be clear about, okay, when a transfer of sale is going to happen, what's the triggers for those? Who's controlling reserve prices? And obviously, worst case scenarios, if we're talking about defaults and terminations, what, again, are the different contingencies that have to be addressed? You don't want to be dealing with that aspect of things through lawyers at the end when you're in a fight. Everything's going to be much more expensive for everyone, as opposed to resolving it at the outset and having a solid agreement on that. And obviously, flowing through from that, make sure you've got proper communication provisions that expressly set out meeting requirements, reporting back requirements, so that it's clear when the communication piece is supposed to happen. And if you run into a smaller dispute or any kind of dispute along the way, are we going to mediation? Is it arbitration, or is it lawyers at 20 paces? So something to consider there. If you move on to the next slide, Mitch, so I'll just run through the economic entitlement side of things. First off, I'm sure the question is, what is it? If you've got land over $1 million and you, in this case, Bob, is obtaining an economic entitlement out of the land, so a sale in share proceeds, a sale in share in the capital growth or rent, or anything that's referenced against those, and that goes back to how we're terming the remuneration that Bob is getting. Because if it's referenced back to those items, again, the SRO has a way to attack this and to try and assess duty against it. Well, if that, unfortunately, were the way it was structured, Bob's going to be up for the stamp duty that he was likely trying to get around by entering into this sort of development arrangement instead. Now, downside, significant downside, obviously, in addition to the tax being applicable, is that the duty would actually apply at the point that you've entered into the development agreement. So it's an upfront cost, and it's an upfront tax, as opposed to stamp duty normally only kicking in later on when transfers are actually completed on land. So if you're going to try and work around it, the workaround is at the very start when you're dealing with the development agreement and having your arrangements properly in place. Workaround may well be the wrong word for that, but having it properly in place so that you don't trip over any of these duty obligations. So considering how we might structure things so that we don't have any of these economic entitlement duty obligations, what are the relevant considerations there? Well, basically, the SRO is looking at this as, is Bob actually just getting a proper fee for service for what he's doing? He's a builder, he's constructing these houses on property, and he happens to be getting paid out of the sale proceeds. Obviously not an unusual thing in a development sort of scenario. Now, the SRO is looking at it as, is he just getting an industry-based, market value-based payment for his services? Is this just specifically, okay, we've agreed on X price for me to deliver Y, and that's the market payment for what he's getting? If we do it strictly like that on a fixed fee kind of basis, obviously hard for the SRO to say it's an economic entitlement situation. Becomes a little bit harder when you're working through a pretty usual remuneration scenario where the agreement is just a profit split or a price split on the sale of the third lot, for example. In that sort of situation where you're referencing back against the actual proceeds of sale, you're obviously falling more directly into a category that the SRO is attacking. At the same time, the SRO does acknowledge that those sorts of arrangements can be usual. Project managers, as an example, can be usual in the industry. And then it becomes, and we again fall into a risk issue here, then it becomes a question of SRO discretion. To what extent is this really an arm's length arrangement between a landowner and a third-party service provider? Is it in line with what the market is expecting? Again, we've got a few things to bear in mind there. Construction cost, what's the usual profit level, etc. We do need to be aware that in this post-COVID time that the SRO is very much looking at trying to protect the tax base and collect in as much revenue as they can. And if anything looks to the SRO as a pure profit sharing arrangement, so say Bob is not a builder, he's just come in to help out Main Raj as friends of his with this development, and he's going to make some money along the way, but he's helping Main Raj develop a home or maybe a retirement sort of income stream for May. If he's coming at it from that end and he's just, say, a pilot and he's got nothing to do with land development at all, it's going to be hard for Bob to be saying he's going to be not subject to the economic entitlement duty, because he's not going to be able to have that argument that it's a fee for service, he's a professional in this area, this is what he does for a living, and he's getting paid proper industry market return for it. So you got to be careful with what's happening in that scenario so that you're not tripping over that by accident. Now, if in this situation economic entitlement duty is unavoidable, say, okay, Bob is wanting to help out his friends in this sort of situation, he's no longer a builder, he's just trying to put up some money to help his friends get the homes that they want and him to get a little bit of return. If that's unavoidable, then the important thing is to make sure that you're recording exactly what Bob's economic entitlement in the property is. So the agreements that are entered into need to specify that Bob is getting 1/3, that his economic entitlement is 1/3. That way, when the stamp duty is assessed, it's going to be assessed against 1/3 of that initial value of the land. If you're not that specific, and the big trap with it is if you're not that specific, the SRO will turn around and say, well, since you haven't specified the interest that you're acquiring, we will deem you to have acquired the whole of the land. So instead of Bob just paying 1/3 of the stamp duty, he ends up paying 100%, even though his net return still, based on the agreement between parties, is on that 1/3 of interest, that last lot. So there's a big trap there, something important to be aware of. Now, as a finish off thing, just as a last alternative to consider, well, what if Bob wanted to hold that third lot after development and subdivision? Say this was in Druin or this was out in Sunbury, it's a development site, there's some space there, and Bob just wanted to in effect hold that rear lot, not build on it, just hold on to that rear lot. He's built the 2 houses for Raj and May so that they get what they want, but he just wants to hold his last lot going forward, maybe develop in the future, bit of a land bank, whatever it may be. In that situation, Bob knows that he will be incurring stamp duty coming into the situation with May and Raj. The issue then is, how do we deal with minimizing that level of tax that's going to be applicable? And at that time, it may be wise to be putting Bob on title at an early point, before any development has happened, before planning applications have gone in, etc. We may then want to have Bob as a 1/3 owner with May and Raj, where Bob's paying that duty early, but he would have anyway in an economic entitlement scenario, but paying that duty early, but paying it on the lowest possible value of the land, as opposed to once the houses are there and everything's built up. So those are the different considerations in that sort of scenario. There are many twists you could put on that same story. So I will open it up to the floor at the moment if anyone's got any questions.
Thanks, Andre. We do have time for a couple of questions. If anyone would like to pop them in the box. We do have one. What is it under $1 million?
So the economic entitlement duty won't apply under $1 million. That being said, obviously a lot of property in Metro is going to be of that value, so it's something to consider. And just as a general reminder to everyone, we do post these webinars onto our website. It can take a couple of weeks for our IT people to get that in place, but we do post this up there if you want to have a look at the content again or review. And obviously always happy to take any questions at any time from anyone if you want to get in contact with either myself, Shuba, or Sabina.
Yeah. And we do, just following on from that, we do have some other resources on our webpage. You're welcome to jump on there and have a look at. Our team is always publishing and posting updates on things as they happen. The law is never still for very long, so you can find our recent articles there on property law topics as well as in other areas of the practice. And you please feel free to follow us on LinkedIn and Twitter and Facebook if you'd like to be alerted when something new is published.
And for those of you in the sort of outer parts of Melbourne, I can see some on the list. Shuba's article on windfall gains tax is definitely a good read and something just to be aware of, because when the government comes swooping in for 50% of your gain as the value of the tax, that's obviously something to worry about.
And just as we begin to wrap up, just a quick plug, if you'll indulge me. David Sharrock's book, Fighting for Enterprise Success Through the Eye of the Tiger, is really great if you're interested in looking at how to drive excellence and high performance in your business or organisation. It's chock full of practical ideas about leadership, team building, vision, workplace culture, customer service, planning, strategy, the whole lot. So I do commend that to you. It also contains nearly 70 samples and templates and tools that we have developed partly in our practice as well. So there might be some things in there that you might be able to take away and adapt in your own business or organisation. If you want to check it out, visit the website and you can download a sample chapter from there if that's of interest to you. So that brings us to the end of today's event. Thank you very much, Andre, Sabina and Shuba for your input today. You can see everyone's contact details there on the screen, so jot that down, or if you miss it, you can find it all on our website as well. So that brings us to the end of today's event. Thank you very much for joining us. As we said before, please don't hesitate to get in touch with any queries. And in the meantime, we hope you have a great day. Thank you.
Thank you.
Thank you.